So far, I think the procedure has been very fair, uh, to the point that in time past, when a similar decision was being taken against a certain electoral commissioner, I mean, that person did not have access to the document to even know who the petitioners were. In this case, it is not the same. The president was magnanimous enough to even give more days for the Chief Justice to respond to the content of the petition. And I don't think there has been any constitutional bypass so far. So I think that if it is about the politics of it, that is different. But in terms of constitutional procedure, and for that matter, bordering on administration, then I think that the process has been quite fair.
Do you think the manner in which the process has been handled would essentially deal with the perception of, because anytime there's a new administration comes into office, gets petitions and acts on it, and this might lead to the removal of the Chief Justice. So the immediate perception that might arise is that they are trying to hound out somebody because the person is not their choice or their appointee. Does the manner in which the petition has been handled help in dealing with that kind of view that might come up immediately?
Well, the politics of it, you cannot falter people when it comes to the politics of it. That is why, in my initial comment, I said that as far as the constitutional provision, administrative processes are concerned, they are going through the due process. As to whether because the person was not appointed by this administration, for which reason they are going through this process to either remove her or not, it's neither here nor there, because there were other chief justices that previous administration met that they did not tinker or they did not attempt to remove. I mean, you can mention Justice Theodora Woods. I mean, a very perfect, woman for that matter. Professor Mills did not see any wisdom in initiating a process, although they all pay some of these petitions. But if a petition or petitions have on the face of it been established some kind of prima facie, then obviously the president cannot do anything than to continue. Now, it surprises me that a prolific writer and a lawyer in the person of Professor Azar will write a petition against the current Chief Justice under President Akufo-Addo, and they will treat that material in a wishy-washy manner. That decision by the former president is more political and very imprudent. And on the face of law, I think he abused the process. Maybe if you look at the political calculation, this person should be there. Of course, in terms of communication, verbally we communicate about 10. 90% is verbally not communicated. You need to read in between the lines to know that. So they don't want to tell us and convince some of us that the current Chief Justice was intentionally or for a political reason nominated and appointed accordingly. If that is what they are insinuating, then it means that the current government will equally have no reason to keep her. Because Theodora Wood, goes through the system of Professor Mills and that of Mr. Mahama. Nothing of that sort happened. So I think that by fair practice, the president, in consultation with the Council of State, by the constitutional provision, is what they are doing, and nothing else. So if at the end of the day, they were not able to establish, wrongdoing or stated misbehavior or misconduct, when the process comes to an end, I think that there is something that they can do than to restore the woman. But if at the end of the day, something untoward, all these things that have been alleged within the petition come out to be, proven with documentation and other things, then obviously So you have no business staying in that office.
Very interesting, because a former member of the Council of State, Sam Okudzeto, in fact, he was on the Council of State that dealt with that particular petition. He says, and this is a quote from him, it was dealt with by the Council of State, and the Council of State at the time said he found no merit in the petition, so he was recommended to be dismissed. But then, he continues, but then the question is that when people are bent on someone, then he found out that other people will be writing petitions. And he continues, personally, I feel like a dangerous thing for any democracy when the public is allowed, or sometimes when you say people, when you say people say that the public has a right. Yes, the question of course is that the public right sometimes is also suspicious, in the sense that not everybody understands the judicial system or the way it works. First of all, he's suggesting first that perhaps there is an agenda to remove the Chief Justice. And so the petitions are emerging as an attempt to do that. And secondly, even if you suggest that any member of the public has a right to put in a petition, he's saying that it is not always that the public understands the judiciary, so they might misinterpret what is being done in the judiciary and jump up and start putting in petitions to remove a CJ for lack of understanding. How do you respond to that?
Well, apart from legal technicalities, that the general public may not have the competency to interrogate. Law is about common sense. And you see, when you have the likes of Domlevo on a committee such as this, it is because of technical competency that he brings on board. And if the issue, one of the issues that I have heard, it's with respect to finances and impudence on the part of the Chief Justice with respect to stated law. So, if that is the case, then there is some kind of misconduct around that particular, issue that has been put in the public domain. I listened to Mr. Samiji on this particular matter. If he's lying, then obviously it is just quite unfortunate. But if that issue constitutes misconduct, then I am foreseeing a situation where if it were to be the previous government that were still be in government, they would have thrown this case away. The venerable senior lawyer, Mr. Okudzeto, should also not insult the integrity of the general public. Everybody is not a lawyer. But if at the end of the day we can read a document and understand, then the law is just about common sense. And the public, as if used could be suspicious, well, is by that suggesting that the entirety of the public have one brain or one mind for which they cannot reason otherwise. That for me is also a subtle way of undermining the integrity and the sensibilities of the members of the public. It is not really fair. And it's also virtually overrating the mind of lawyers, as though they have brains that are by far superior and different from any other profession. That for me is a subtle, insult on the sensibilities of the general public. It is not a fair comment to make that from the public perspective it could be suspicious. Now we have a data, done by Global Info Analytics some few days back that shows that 52% of Ghanaians feel that the woman should go. Even with this, they don't even have the details. Probably they may be influenced by the kinds of things that have been happening, in the judiciary. And that may have influenced that particular decision as far as the public is concerned. That apart, don't forget that the Afro barometer that came last year before the elections put the judiciary as the number 4 corrupt institution in this country. That in itself is not good for our total image. To the extent that the presidency even came second, the seat of government itself came second. And then it means that if a president gets an overwhelming victory, which is very unprecedented, then it means that the public have become, But let me put it this way: the public have become a bit. They have experienced discomfort with respect to, the kind of state institutions, the way they have been run under the previous government. So when they express that in a poll, you will see a particular drift. And so this is not in any way to, as it were, make the issue seem like it's a foregone conclusion. They will have to go through the process fairly, where the transparency is very important, is at the end of it. If probably there should be a constitutional review to the fact that this process should not be in camera, but rather, open to the public so that we can all make a sense out of whatever is happening. Then we can appreciate that, look, with respect to this transparency, there is no way the government will be in good light if they remove her. Or with this process of transparency, there is no way if they remove her, it will create any public uproar. Then we can look at that amendment. That I think that the venerable lawyer sometimes should choose his diction carefully because, as I said, communication, verbal communication, it's about 10%. The non-verbal, or within that is not communicated. It's 90. So when you read in between the lines, look at some of the conclusions that you can arrive at.
Interesting, because I'm still staying on him because he was in the Council of State. So his thinking is very important because he also is of the opinion, and perhaps that might be one of the reasons they decided to dispose of the first petition in the manner in which he did, is that now the question, of course, is that when you suspend a Chief Justice, the signal that it sends out into the international community is quite serious indeed. Then he continues, I can assure you that a lot of investors will withhold their investment from your country by virtue of that kind of situation. So,
the point is that when you reason in that manner, have you seen the content of the petition yourself? In that manner of reasoning, have you seen the content of the petition yourself? Are you by that insinuating that if it is found out that the Chief Justice had led someone to be killed, for example, and because of that reasoning, international community investment and other things, it should be let go? I think that they seem to be more political than legal. And that is where there is an obfuscation of the issues. Because the way and manner, for example, I see the fervor with which the minority is attacking this particular issue. When, the issue itself has not even started. It means that you guys are rather doing more partisan politics than thinking or than using the legal glasses or lenses to approach the matter. That is how I see it. As for Uncle Sam, I know he is very partisan. He is very partisan in his approach. In time past, sometimes I've listened to him. He comes out to rationalize certain issues that in the public domain, everybody is thinking that this is what it should be. But Uncle Sam will come and give a different, interpretation, a different twist to the matter. I mean,
he is partisan. He sounds partisan for you?
Yeah, he's always been.
Partisan towards which party?
The MPP.
He sounds more MPP anytime he speaks.
I'm talking about Sam Okudzeto.
Yes, I know.
Oh, yes. That is how he appears to me. Very, very. Very, very. Occasionally, maybe he may have a very, soft view on certain. But when it comes to issues that you really, it's about law and it affects the other side, you see that you would defer to the other side. That is how I've always think.
Now, now let me read to you the minority's view, because you're talking about the fact that they are reading politics into it. This seems to be suggesting that they are reading politics into it because this is politically motivated. This is what they say in their press statement. President Mohammed's actions confirm what many have long suspected, that this is not about accountability but about raw political control. His public declaration in Akosombo that he intends to, in effect, balance the judiciary by appointing NDC aligned judges exposes the or ulterior motive behind this sudden rush to remove the Chief Justice. This is neither good governance nor credible attempt to reset of the judicial. It is tyranny. If the president believes he can strong arm the judiciary into submission, he must be reminded that Ghana is a constitutional democracy, not a fiefdom. The people of Ghana will not tolerate the subjection of judicial independence for partisan gain. That, to them, this is an attempt by President Mahama to control the judiciary.
Once again, so now this is a twist of the information that is in the public domain. What President Mahama said then, and sometimes I don't know what NBC communicators do. What he said then was the fact that the members of the NBC who are lawyers must equally be interested. You see, many people like private practice. So the lawyers belonging to NBC fraternity must be equally interested in what? Getting into the judiciary and occupying position. Because you cannot always sit there and cry foul that you could see brazenly the appointment of people onto the bar that are MPP biased. Everybody in this country has had cause to complain about that. And for which reason even Mr. Kandaba in their security report that came out said that the way and manner the judgments were going was quite dangerous to the security of this country. And that is what the report said. And he put it out there in the public domain. So this is disinformation and misinformation, if you ask me. You are creating a situation that will make Mr. Mahama look bad, that this is what he said, when in actual fact, that is not what he said. He told them that they should be interested. It's not only about private practice where you are going to make money. No, you should be interested so that you do not cry foul tomorrow that ABC and D, they have passed the court with their own, people of the same inclination. That is exactly the information that came to me. So they just created their own premise and then created a conclusion out of that particular premise. When in actual fact, the premise is wrong.
And considering that this is happening because President Mahama is a politician, got into office through the platform of politics. What does the NDC need to do, the government need to do to convince people that perhaps the allegation that the MPP is making is not true, that this is an honest act on a petition, and that this is not a calculated attempt to hand out the CJ?
Well, there are a cross-section of the populace that there is nothing that you can do because of partisan view. It is polarized. There is a cross-section of the NDC that is equally polarized, and they will see everything right by the process. So sometimes it is not always about government communication. It's about getting fair-minded people whom the public trusts and can look at the issue dispassionately, right? I don't think that if what Mr. Samiji put out there with a view that the Chief Justice is entitled to this when she's going on a private trip and on a public listing, she's entitled to this. And if she does otherwise and commits state resources to that effect, and later on realizes that so and so has happened, and she is refunding or is reported to have refunded, a misconduct has already been occasioned. You see, a misconduct has already been occasioned, and this is purely financial mismanagement. And it doesn't have to take a lawyer to see that. It will have to take someone with professional competence in that manner. So apart from you reading the law as a policy, so to speak, the rest is the deed itself. And any other thing that, is constituted in the petition, of which some of us are not aware of. And so government too, sometimes there shouldn't be, the communication shouldn't be reactionary. There should be proactive. If politically, in terms of strategy, if it serves government well, to give the petition to people who are fair-minded, who are not necessarily lawyers, who are fair-minded in the public space, to study or come out with those particular portions that, will help communicate better for people to see that indeed A, B, C, and D happen, then certainly, government will look good. Apart from that, if you listen to Mr. Afenyamakis, for example, when he says that, oh, the petition is frivolous. Now, the question I ask myself, is it the case that he has seen the petition? So if he sees the petition, then it means that government also loses nothing if they make those who are fair-minded see the petition as well and read it thoroughly, and that in itself should shape public discourse as far as this particular case is concerned. Because the way and manner the minority has descended into this, it creates the impression that the woman is an MPP woman. What do they gain with this kind of favor and attack? And what do they lose if they stood aloof? Is it the case that, for example, Supreme Court cases that can last for 2-3 years, and the case would not have even been called, and when it took another matter, within some few hours, a panel had already been prosecuted by the Chief Justice, the matter had been looked into, an injunction brought? I mean, it doesn't look good for the Chief Justice in terms of the image. And I've always not liked a particular decision that they took, of which was that. Telling me, for example, that my birth certificate, my birth certificate that bears the name of my father and my mother, who are Ghanaian. You tell me that my birth certificate doesn't make me a Ghanaian, and that a document that just came, that is Ghana card, whether determines my Ghanaianness or otherwise. I mean, who does this? And she could not even put up any better defense when it got to the vetting for appointment. She couldn't even put up any better defense. So such situations create some kind of ridiculousness, in the minds of the public about the way they were doing things. So it's as if, well, whatever be the case, we will have to make sure that this is how we go about the judgment. Take, for example, this issue that came up was referred to the MPs that were young from Parliament. And I said that this thing that they are putting the Supreme Court, the situation that they are putting the Supreme Court, the way and manner they are making them, they are brought into things that are very partisan and things that, deal that border on the legislature in that manner. They will create problems for the image of the Supreme Court. And so when they admitted it and started the process, I said that there is no way the judgment that will come from the Supreme Court will be legal. At best, it will be technical. And that it will make them look ridiculous and ludicrous. And you saw the judgment that came. And Ghanaians decided that no, enough is enough. They cannot go in this manner. The Supreme Court, yes, you have had your way. Ghanaians will also have their way. And that all of these things influence, the majority of Ghanaians to vote overwhelmingly against the MPP. You see, all these things, happen. And it rather, created a bad image for the MPP and the leadership. As if everything they must have their way, because there is a public perception that most of the people appointed there are their own people. I mean, have you had a situation where one president has appointed about 13 Supreme Court justices in a regime? I've never seen that before.
Doc.
Yes, sir.
Thank you. Thank you very much for speaking to us.
You're welcome, my brother.
Dr. Jonathan Asante Otchere is a political analyst. Join us on the line for a quick conversation on the issues